All right. Thank you very much. Please be seated. Okay. Okay, let's get on the record, please. Okay, that's our technology. Sports and doors. No. Just half of it. Just put it flat. There we go. That's good. No? Taylor, what's your preference?
Your Honor, my preference is that it not focus in on the table where my counsel notes will be.
Okay, so angle it this way.
They went.
Good.
Good.
All right. Thank you. Okay, we are on the record. This is State of Idaho versus Bryan C. Kohberger, CR 29222805. Mr. Kohberger is here in the courtroom. He is represented by the team of Ann Taylor, Jay Lobson, and Elisa Massa. We also have representing the state, Mr. Thompson, Bill Thompson, Ashley Jennings, Ingrid Beatty, and Jeff Nye. We have several motions set for today. The state's motions are motion for protective order that is related to the investigative genetic genealogy DNA issue, which is related to the Mr. Kohberger's motion to compel, seeking those genetic genealogy information and discovery. We also have a motion to reconsider the order staying time for speedy trial. There's also in opposing that, a second motion to stay proceedings regarding alleged irregularities of the grand jury. And from the state, we also have a motion to compel notice of defense of alibi and a motion for scheduling order. So that's what we're going to hear today. I think we're probably going to use most of the morning with the motion for protective order and the third motion to compel. We expect some testimony from Mr. Kohberger's team, and that's where we're going to start. So anything preliminary, Mr. Thompson?
No, Your Honor. Thank you.
Okay, Ms. Taylor?
Nothing preliminary, Your Honor. We're ready to call it.
Okay, so we'll do that, and then we'll move to argument from both sides. I've thought about who should go first in terms of the argument. Mr. Thompson, go ahead.
No, that's good.
Yeah, I mean, who would first make the argument on the protection order? Would you prefer to do that after you hear the argument from the defense?
It may make more sense, Judge, to do that. I think the record will be better for Your Honor.
Okay, that's what I suggested that. Thank you.
Yes.
All right, so we'll hear the testimony and argument from Mr. Kohberger's team, and then to the state.
Your Honor, just for the record, Mr. Nye and Ms. Beatty are the ones handling this particular motion. Ms. Beatty has the witnesses, the proposed witnesses, Mr. Kohberger and Mr. Nye, of course, briefed the matter and will be prepared for the legal argument.
Okay, excellent, thank you. All right, call your first witness.
Your Honor, along those lines, I should inform the court that I'll be handling all of the witnesses that we call today. Ms. Matzoff will be presenting our argument in support of our motion to compel and probably the rebuttal to the protection order request by the state as well.
Okay, you all might need to remind me as we go along here.
That's fair enough.
Okay, Ms. Beatty.
For other housekeeping matter, I have some objections that I'd like to put on the record
Okay.
with regard to these witnesses. With regard to Ms. Barlow and Mr. Mercer, the state made its concerns on these two witnesses clear in its reply brief filed on July 14th. But the state believes that calling two attorneys to testify about legal conclusions during a discovery dispute is simply not proper. Both Mr. Mercer and Ms. Barlow consult with defense attorneys on discovery issues, and calling them to testify about legal conclusions in a discovery dispute is tantamount to the state calling prosecutors as staff witnesses to testify about training that they've done in a specialized particular area. That's a path I don't think we want to go down, and it's not relevant to the court, and it doesn't fall within 702, which requires specialized knowledge for the fact finder, which is the court in this case. Additionally, Ms. Taylor is an attorney practicing in Idaho who's well regarded and seen as one of the preeminent defense attorneys in the state. So there's nothing that these witnesses can tell the court that Ms. Taylor can't simply consult with them about and then argue to the court. So our position is that these witnesses' testimony is duplicative of whatever Ms. Taylor can argue, and it does not fall within the scope of 702. With regard to Gabriela Vargas, the state is objecting to her testimony as well, Your Honor. We received her declaration just yesterday. There was no CV attached. Ms. Vargas is being submitted to this court as an expert witness, and the state has no way of vetting her expertise without a CV. There is no way for us to verify anything in her affidavit. It puts the state in essentially an ambush position where we're being presented with this witness with no way to verify her qualifications. We would ask that this witness be excluded from testifying today as well. And then finally, the state would just make a blanket motion in limine that these witnesses not be allowed to testify about legal decisions or legal arguments. Thank you, Your Honor.
Ms. Taylor.
Yes, thank you, Your Honor. Your Honor, the first two witnesses that the state objects to, Vicka Barlow and Steve Mercer, are two people who have been known to the state for quite some time. What they say to you in court now is their objection was made known on July 14th in their reply to, in support of their protective order after we did a response to their motion for protective order and an objection to it, that it's not an objection to them testifying. They spent a lot of pages telling the court why the court should not pay any attention to the declarations that were attached to our third motion to compel. So that's not an objection to them testifying at all. These witnesses have been made known for a long time. They were certainly known last week when we had a planning session and we talked about the number of witnesses that were going to testify. No objection was stated at that time either. Waiting until today, when those witnesses have both traveled and been here and been prepared to testify, that's an ambush, Your Honor. They're here, they're prepared. Their testimonies are relevant to the issues that the court has to decide. They're going to talk to the court about two different things as it relates to our discovery rule and the information that Mr. Kohberger is seeking so that we can do our job. Your Honor, you're going to hear from a witness, Leah Larkin, Dr. Leah Larkin as well, and she's going to talk about the process of genetic genealogy. Both Ms. Barlow and Mr. Mercer are attorneys. Both are well-versed in criminal defense. Both are well-versed in DNA and genetic genealogy. The state's position has been that this is not discoverable because we're not going to present it at trial. That's not the end of the story. That's not the discovery rule. And those are the things that Becca Barlow and Steve Mercer will talk about. Becca Barlow has a lot of training in DNA. She does a lot of teaching on DNA as well. It's not a simple little process, and they'll describe what kinds of materials we should have in discovery. Mr. Mercer will talk about what we will do with those kinds of materials and why they're necessary to Mr. Kohberger's presentation, the preparation of his case. They'll talk about our constitutional duties to Mr. Kohberger. Those are not conclusions. Those are things that have to do with this material, these things that we are seeking the court to order the state to hand over to us, and why they're necessary to the preparation of the case. So for those two witnesses, I can make the argument, but I don't have the expertise in the DNA or the genealogy that the court needs to hear to understand that they fall squarely within our discovery rule. Your Honor, I'll speak about Gabriela Vargas now. Her declaration was disclosed yesterday. Much of that declaration has CV-related items in it. It talks about her background, her training, right in the body of that declaration. That declaration is not as soon as we would have wanted that. Gabriela Vargas met with me a few weeks ago, and for personal reasons that I'm not going to put on the record, she was unable to complete that until a later period of time. So that one is late. I know that one came in yesterday. She's here, she's prepared to be cross-examined by the state, and certainly there are many other remedies besides just excluding her. The court could allow us to present her testimony, and the state doesn't feel that they've had opportunity to cross-examine her or present a witness in response to her. The court could leave this open and take that up. The court could even order Ms. Vargas to appear by Zoom for further cross-examination. But we should at least let her testimony come out here in court today. She's here, Your Honor.
Your Honor, I think Ms. Taylor has just conceded that these attorney witnesses are going to be testifying about the scope of discovery rules. I don't think that that's appropriate. I think that Ms. Taylor can make those arguments to the court, but having fact witnesses interpret the law is not appropriate in a discovery dispute. As to Ms. Vargas, our understanding was that there were 3 witnesses testifying today, and that was our understanding up until yesterday when we got into town. So we would ask that Ms. Vargas be excluded. And I would note that we made our objections to these witnesses clear when we asked the court to disregard the contents of their declarations in Mr. Nye's reply brief. Certainly we're going to put that same objection on the record. Thank you, Your Honor.
Thank you. Well, a couple of things. I'm concerned about these opinions about sort of constitutional law or the procedures of discovery. I think that's fully capable for all of the counsel here and for me. Those are going to be my decisions. However, in reading through, and I have read through all of the declarations, pointing on specifically genetic genealogy and their experience with that within the law, I think does have some relevance, potentially. And I think that it would go to the weight of the consideration. The other thing that I am concerned about is this is a death penalty case. And if I deny particular presentations that one or the other side believe have some bearing on the case, it's probably more wise for me to allow it, even if it might be on the edge, than not allowing that method. It's especially important in a case like this to have a record for appeal. So I'm not saying one way or the other how this might fall, but I think it's important to preserve the record. Now, however, I don't want to get into arguments about the law or what that exactly means. I think I have a pretty good understanding of what the issues are about the genetic genealogy issues and why the state wants to get more information about that. I also understand why the state believes that it has nothing to do with the case. That's what I'm going to hear from today. And I think it's important to have both sides weighing on this. Now, with regard to Ms. Vargas, she is here. I don't know where she came from, how far away. I'm inclined to just allow the state to come back and address that if we need to. Also, file another brief objection, and I may decide to reject that. So that's where I landed on all of that. So I'm going to deny the objections, overrule them, and we shall proceed with hearing the testimony. Now, if you get too far into this is what the law requires, okay?
Thank you.
So call your first witness.
Your Honor, I made one point of clarification. It occurred to me while listening to the court talking about genetic genealogy and really that being the focus. There are a couple of other areas contained in the motion to compel that have to do with the other DNA that the state doesn't have complete discoveries to us that are included in that third motion to compel that are up for today. The big focus has been the genetic genealogy piece, but I wanted to make sure that that was still in the scope.
Well, my understanding was that the state did provide all the information about the laboratory, we'll say the laboratory DNA that was, that analysis was not related to the genealogy DNA. Am I mistaken about that? What are you saying that they didn't provide to you?
Your Honor, in our third motion to compel, we had a section called Standard Lab Discovery, and that has to do with other DNA profiles found at the scene. They have provided full discovery for the sheet, the DNA found on the night sheet, but not the other 3 unidentified male DNA samples, 2 from within the house, 1 from outside of the house.
All right. So if I'm understanding your question there, or your assertion that we're talking about 3 potential analysis of DNA that was not provided to you, but that has no connection to Mr. Kohberger.
Correct.
Okay, any response?
Your Honor, we didn't realize this was going to be an issue today. We have given
I
the
didn't either.
defense everything that we received from the lab. They've asked for DNA workups on other people. To the extent that they don't have them, they weren't done. We can't produce something that doesn't exist. We've provided everything. There's one outstanding lab report that relates to the forensic examination by the lab personnel of the crime scene itself. Will be received today. That's the only outstanding lab report. Everything else, along with all the notes, is what there is, and it's been provided to the defense. And if they're hoping that there's something else there, it's not there.
Taylor?
Well, Your Honor, it's part of our third motion to compel. It's still something that we don't have. We also don't have the unexpected corrective actions, unexpected results from the Idaho State Police Forensics Lab for the 6 months before and the 6 months after November 13th, 2022. We did get some, but it's a narrow scope, and we asked for the full year, 6 months before and 6 months after. That's also in our motion.
I understand your responsibility is to turn over every rock. But you can't get things that don't exist as well. So, I mean, there has to be some level of trust in discovery. You're all sworn attorneys. And so Mr. Thompson is saying that there's one more lab report that is coming your way today, I heard you say.
Maybe not today. We were waiting to receive it so that we can process it for discovery. It's supposed to be in any time.
Okay, I misunderstood that. So it's coming soon. It has to come soon because we're 6 weeks away from the trial. So we're going to be very rushed about a lot of things. But I'm going to talk about that a little more later too. So what about the other claim, Mr. Thompson? Do you want to address that? The other mistakes?
Corrected action log, unexpected result log. We have that in part, but not the full scope.
I don't know what exists that we haven't received. We provided all the requests to the lab, and they've assured us that they have provided us with everything that they have within the scope of those requests. I'm not sure what else to say. I mean, we can make a supplemental inquiry to clarify that after we finish in court today. But I'm kind of sitting here saying, Judge has given me everything we know to exist.
Well, that would be wise to check on that.
We will.
Because we don't want this to come back on the eve of trial.
Yes, sir.
Or, 4 years from now at an appeal.
Yes, sir.
So we want to make sure that we have combed through all the information that has any bearing or argument of bearing on this case. That's how I'm.
Ms. Jennings is making a note right now. We'll send the inquiry out later today.
Okay.
Thanks, sir.
Your Honor, just for point of clarification, we also ask for all emails, text messages, electronic messages, or other messages. Some have been provided, but we don't have assurance that that's all. And so for the same reason, we want to make sure that we have the complete copy.
Okay, Mr. Thompson.
We have told them, we have given them everything that we know to exist. We've asked the lab provided it to us, we sent it to them. At this point, all I'm hearing is speculations. They think maybe or they wish something else was there. But as far as we know, it doesn't exist. I don't know what else we can say. You can't respond to something that isn't real. Sorry, Judge.
I mean, we're just sorting it out.
Yes, sir.
Making sure that everything that there is shared. Except for the ones that you don't want that.
Absolutely.
Shared.
Yes, sir.
And that's one of the reasons we're here.
We'll make an additional inquiry to the lab to see if there's anything else in the form of emails that they haven't already provided to us.
I would add, I mean, there are times, okay, in the world of the law, that sometimes people forget to do things, or sometimes things fall through the cracks, and so it's always healthy to make sure that it is done thoroughly.
Absolutely. Thank you, Judge.
Thank
You're now ready to call Steve Mercer.
you. Okay. Just one moment. Are your experts in the courtroom right now?
Yeah.
Do they need to be in the courtroom?
Your Honor, I'd ask that they be allowed to remain in the courtroom, seated where they are, so they're just kind of alone.
Right. Any objection to that? I don't know who to point to here.
Or we'd also have the witnesses excluded.
I'm going to exclude your witnesses, so they're not hearing what the other witnesses are testifying by, and that'll be, I think, a cleaner, more accurate response. So then I don't want to have them reacting to the other testimony. We'll hear each witness's testimony be independent. Okay, so if you please have your other experts excluded from the court.
Where would the court like them to go? This is a media-intensive environment, and I don't want them to be bothered by the media while they're waiting
The law library.
for May I escort them there?
Sure. Thank you. Sorry, Mr. Mercer.
No, no, no.
Thank you, Your Honor.
Okay. Thank you, Ms. Taylor. Okay, Ms. Mercer, come on up. Please raise your right hand. Hey, yeah, please.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do. Thank you, Mr. Mercer. Go ahead, get some water there. I'll take care of that. And once you're seated, will you please state your name and spell your last name?
Yes, my name is Stephen with a PH Mercer, M-E-R-C-E-R.
All right, thank you, sir. Okay, Ms. Taylor?
Good morning, Mr. Mercer.
Good morning,
What city and state are you from?
Rockville, Maryland.
What do you do for work?
I am a licensed attorney in Maryland in the District of Columbia in the field of criminal defense with area of specialization in DNA and forensic litigation.
How long have you been an attorney?
I was licensed in the state of Maryland in 1995 and in the District of Columbia in 1997. I'm also a member of several federal bars, including the Supreme Court, where I appeared as co-counsel in Maryland v. King, a DNA database case from 2013, as well as the Fourth Circuit, the D.C. Circuit, and a number of federal district courts.
I want to back up a little bit and have you tell me about your educational background.
So I have an undergraduate degree, bachelor's degree in English from Syracuse University, 1984. Juris Doctor JD from the District of Columbia School of Law from 1994.
And you mentioned you have a specialty in DNA. Where does that come from?
So my experience with DNA began with the first constitutional challenge to Maryland's DNA database statute, and that started in 2002 in the case of State v. Raines, where it raised a Fourth Amendment challenge to the compelled collection of DNA from convicted offenders. Prevailed on that case in the trial court as appealed to the Court of Appeals, which is now called the Maryland Supreme Court. The Maryland Supreme Court, in a sharply divided 4-3 decision, reversed, sent it back for trial, tried the case, and that was really the beginning of my experience with forensic DNA litigation. And then from that point, I continued in that field, attended training with the District of Columbia Public Defender Service. I began to collaborate with the Innocence Project in the Forensics Division at the Maryland Office of the Public Defender, doing indigent defense work and innocence work, and began to work closely with DNA scientists who actually did the wet chemistry work, had numerous opportunities to tour law enforcement labs, including the NIST lab, as well as Montgomery County's lab, Bodie Technology, the FBI lab, as well. And so I continued working in the field, providing both direct representation in DNA cases as well as consultation through my private practice. And then in 2010, the public defender recruited me to head up the forensics division at Maryland's Office of the Public Defender, which is a statewide public defender system. And then there, I really dived much deeper into the field of DNA forensic litigation at that time. And if there's some questions, I can explain that further.
I may ask you some others about that in just a moment. Would you tell me about any publications, any articles that you took?
Yes, so I published an article, co-authored an article in Maryland's DNA Databank back in the early 2000s following the State v. Raines decision. I also published an article in the NYU's Law Review about shadow DNA databanks with a co-author, Jessica Grable, and those are the principal articles with respect to forensic DNA.
And I think you mentioned a couple of professional organizations that you belong to. Are there others?
Yes, so I'm a member of the jurisprudential section of the American Academy of Forensic Scientists, and I've given presentations there. For example, in 2018, I gave a presentation on proposed regulation of the field of forensic genealogy. And then I'm also a member of the National Criminal Defense Attorneys Association and a number of local bar associations in Maryland, as well as the State Bar Association.
You mentioned forensic genetic genealogy just now. Can you tell me your background related to that?
So following really the advent of forensic genealogy in 2018, that is when I had the opportunity to litigate cases, criminal cases involving that technique, the testing and the investigation related to the testing, and to receive discovery of the testing and the interpretation of the test results that were obtained through searching of genetic databanks.
You are here on Bryan Kohberger's case. How did you become involved in this?
Yeah, so the question was, what would a reasonable defense attorney do when confronted with DNA evidence that needs to be litigated? What are the minimum practice standards? So I'm not here to discuss Idaho's discovery rules or offer legal opinions about constitutional standards. Rather, my area of focus is based on my experience, training, and expertise in forensic DNA litigation, and what a minimum practice standard would be for a reasonably competent trial attorney who must comply with their duty to investigate a case on behalf of their client.
And is that because of what you get when you get genetic genealogy materials?
Well, yes. I mean, forensic evidence is often central in the case, and DNA evidence in particular. And so when there's an item, for example, here of an environmental sample of trace DNA evidence that, as I understand it from reviewing the pleadings, was twice tested, first for an STR profile and then later for a genomic profile, the question becomes, what is the minimum practice standard for an attorney to be effective in your representation of a client given that type of evidence?
When you're talking about two samples happening, or two tests happening, why should an attorney know about that?
Well, there are a number of reasons why it's crucial for the attorney to investigate any testing of evidence that is central to a case. And again, here it's an environmental sample of trace DNA that is being tested. And so it's essential for the attorney to know, for a number of reasons, about the the details of the testing and the investigation when we're talking specifically about forensic genealogy. Number one is there's pretrial concerns. And those pretrial concerns that can be raised would involve suppression issues and potentially Fourth Amendment issues. These are questions that are very much evolving in the state of our litigation. But to understand the viability of a Fourth Amendment challenge, there has to be a factual investigation. There has to be a determination of the conduct that law enforcement undertook during the forensic analysis of the genealogy. So, for example, was it fast and loose? Was there searching of databanks that violated the terms and conditions of those databanks? Was there surreptitious DNA collection from individuals, targeted individuals in family trees? So these are very fact-specific inquiries that the attorney must know in formulating a suppression challenge under the Fourth Amendment, because it's all about reasonable expectations of privacy. And what's really critical here to understand, and this is close to me from my litigation, early on, the government and law enforcement's argument was always there are minimal privacy interests at stake because forensic DNA profile is like a fingerprint, and it says nothing about who the person is. But now with forensic genealogy, we're talking about genomic profiles, potentially whole genomic profiles, or at the very least a SNP profile, single nucleotide polymorphism profile. Single nucleotide polymorphism. An SNP profile that contains a vast amount of information that is very, very private. And so this is a real game changer in the privacy interests that are at stake, and that the attorney needs to understand in investigating the case to assess and to evaluate that suppression issue, that Fourth Amendment issue. So that's one issue pre-trial. There's also concerns about reliability. And by reliability, I'm not talking necessarily about the forensic genomic profile, but I'm talking about the STR profile. And again, because as I understand it from the pleadings, there were multiple tests on the same evidence, environmental sample of trace DNA. One produced a STR profile that I understand from the pleadings is represented as being a single source male profile. The reliability of that needs to be investigated, and certainly through one aspect of that is investigating the laboratory documentation that is provided for the STR testing. But we also have to appreciate, and again, I'm not a DNA scientist or a biologist, but I'm an attorney that works with experts, and I need to know what type of expert to hire. And one thing that I do realize in looking at this is when there's multiple tests of the same piece of evidence, and you have a genomic profile, in other words, potentially the entire human genome that is typed from this environmental sample of trace DNA, or at least an SNP profile, which is somewhere in the neighborhood of 700,000 locations of data. What does that tell us about the STR profile markers? So for example, the STR profile markers, which are typed, are 20 out of 30,000 STR markers overall. And so what I would be investigating with a qualified expert is, number one, I don't know from the pleadings if there's a whole genome profile that's been developed for the forensic genealogy, but if there is, that should contain STR markers. What does that tell us about the reliability of the STR testing? Is there any potential for artifacts? Is there any potential for an undetected low-level mixture? Those types of questions that are potentially available to inquire and ask about where you have multiple tests of the same piece of evidence, and it's an environmental sample of trace DNA. Now, if it's just an S&P profile, I say just, but that's 700,000 locations of information that is like a probabilistic future diary of someone's health, medical, and all manner of conditions that are linked to genetics. That may not have the STR markers in it itself, but it will have information SNP markers in the neighborhood of, so to speak, of STR markers that will also shed light potentially on those STR markers and the reliability of those STR markers. So these are, particularly in a capital case, crucial areas of inquiry that must be undertaken by the defense team in conjunction with experts that they retain. But they can't even decide what experts to retain without having the discovery. And that's the minimum practice standard. And that's a point that I've made in testimony before courts where I've been accepted as an expert in Maryland, D.C., and Virginia, that the minimum practice standard is that the attorney must obtain discovery of the scientific testing of an evidence sample. And that, particularly so in a capital case, particularly where we're talking about an environmental sample of trace DNA, it's absolutely crucial to get that discovery, because then that informs the scope of the investigation, the experts to hire, and what happens. Now, also with respect to the forensic genealogy, it's important not to separate this out into all these different components. It is, you have the S&P testing, and then you also have the development of these family trees through database searching. This is all part of the same testing and experiment. They go really hand in hand, and you can't unravel them. They really have to be considered together as a single cord of different strands of the testing and experiment, because the attorney needs to know how these family trees have been developed, because we're talking now about trial issues, and the government is introducing the STR profile. They have to introduce statistics that explain the significance of any STR match that the government is identifying as central to its case. And so the defense must investigate ways to cross-examine those statistics and the rarity of that match that the government is attaching great significance to. And so an area to look into and to inquire about are the limits of the statistical tool that the government is using or the state is using, which is based on the premise that sort of what's called the random person not excluded, and that's answering the question of the rarity of a profile in a population of unrelated people. But the key point there is unrelated. So we know there's no universe where a STR profile has no relatives. And in fact, in a case involving forensic genealogy, the way that the defendant is identified is by searching a pool of related people. And so we need to be able to investigate and evaluate the rarity of a profile within a related population. And that's a different question than what the government answers with its random person not excluded statistic that is typically used. And so, again, without the discovery of the forensic genealogy, both the testing as well as the experiments that are done with the test results, i.e. the database searches, as well as the family tree build-out, the attorney can't investigate that. And in that situation, by not investigating it, is not complying with their duty to investigate that is required, especially in a capital case.
I've heard you say that when you have a sample, in this case, a DNA sample from a manuscript, that there's STR testing done, and then when you go, when you have genetic genealogy testing, you end up with whole genome testing or an SNP profile. Did I understand that?
Yes, and it's unclear to me at this point what type of genomic profile was developed, whether it was a whole genome sequence or whether it was an SNP profile, which contains about 700,000 locations of very personal, private information.
I think I heard you say that no matter which one of those were done for genetic genealogy, that you need to look at those to test the reliability of the STR profile. Did I hear that right?
Yes, so this is, as an attorney and not a scientist, but as an attorney who has a duty to investigate, this now is an area where the attorney will look to retain a qualified expert who can evaluate and assess the linkages between the SNP profile or a whole genomic profile and an STR profile. To be sure, an SNP profile or a forensic genomic profile can't be searched in CODIS. It's not that type of situation. They can't be directly compared. But there are techniques that can evaluate if it is a whole genomic profile, you would look to a scientist who then would be targeting the areas of the whole genomic profile that comprise the STR profile to then evaluate the reliability of the STR profile, the potential for any mixture, the potential for any artifacts in the STR profile. Or if it's an SNP profile which doesn't have the STR locations in it, then you would look for an expert who understands that the neighboring regions around where the STR markers can be evaluated and assessed to provide information about what the STR markers would be.
Can I clarify something?
Sure.
So what you're saying is that you need to look at the qualified scientists who have to look at the SNP profile to compare it to the SPP profile for reliability of the SPP profile.
The STR profile.
STR.
Yes, so there could be clues, absolutely, that could be discerned from an analysis of the SNP or whole genomic profile. Because again, we're talking about two different tests of the same piece of evidence. And there have been, in peer-reviewed publication, I mean, one that comes to mind is Jae-Wah Kim, who published in the journal Cell about how an SNP profile can be linked to an STR profile. And that's by zeroing in on sort of the neighboring regions and examining those. So again, I'm not a biologist or scientist, but I'm an attorney, who has a duty to investigate, and to investigate requires hiring experts to examine this data, this discovery that hasn't been produced yet. And so that's why the minimum practice standard is to get that discovery so that the attorney can then assess that discovery and then retain a qualified scientist to help understand the extent to which the SNP testing will shed light on the reliability of the STR testing that has already been done in the same discovery.
Okay, so that having that profile on the SNP can verify the legitimacy of the STR.
Right, so that's my hypothesis. That's what I go to the expert to inquire about. Because again, this is a very much an emerging area of forensic science and litigation.
Sure.
And
Evolving.
yes,
I'm
evolving.
going to object again. I don't believe that this witness is qualified to opine on what's needed in these scientific processes. He just indicated that it was his personal hypothesis. I would remove my objection on it.
Well, I'm going to overrule that because
Go ahead, ask your next question.
When I'm talking about either the whole genome or the SNP profile, am I looking for just like a sheet of paper that has a bunch of numbers on it, or is there a packet of information that I need to go to my expert?
No, you need the raw data of the profile along with, it's similar to the sort of data that you obtain for the SDR testing. You get the raw data of the profile, you get the laboratory protocols, you get all the bench notes, how the profile was generated, but also you should get the discovery about how the profile was then searched in different databases and family trees constructed.
That was going to be my next question. I heard you say that we can't look at this whole genome sequencing or the SNP in one category and then look at the building the tree to identify from the genetic genealogy piece, the genealogist piece, in its own separate area, that they're not two separate lanes that they combine.
Yes, they go hand in hand. You do one or the other. I mean, they go together.
Why?
I'm sorry?
Can you tell me why? Can you explain why you say they go together, why I need both?
Oh, well, the SNP profile is what is searched in the Ancestry database to then identify potential relatives. And then family trees are built out. That's the object of the SNP testing. What's important to know from a defense perspective in terms of trial work and potential areas of cross-examination, the government is going to be introducing a statistic that is premised on the assumption of an unrelated universe of people. So what's the chance of finding a profile in a population where there's no relatedness between that profile and anyone in that universe? And so, as you know from talking about this whole concept of forensic genealogy, people who are related have similar DNA. And so the statistics change when you are talking about the chance of finding a profile within a related pool or related universe of individuals. And that's a legitimate area of inquiry from cross-examination for the defense to demonstrate the limitations of the statistical questions that the state is presenting to its expert witness. And to do that, you need to know, for example, who the population of related people are, because often from my work on the forensic genealogy, what I've seen is that when a match is found, when the STR match is found, then all building out, all further testing stops on the forensic genealogy side. And so it's important to know who hasn't been tested on the related person side in terms of developing cross-examination about the limitations of the statistical tool that the state uses in its case to demonstrate the rarity of the match that they're presenting.
Have you received genetic genealogy materials in your cases? I think I heard you say that.
Yes, so which wasn't surprising to me, because even though typically the government doesn't seek to introduce the forensic genealogy, in its case, it nevertheless is evidence that is a scientific test of material in the case. And so the discovery rules typically call, for example, in Maryland, in the District of Columbia, call for discovery of scientific testing of evidence in a case, and that's regardless of whether the government is going to introduce it or not. DC is a little different, where it requires either a materiality showing or that the item is introduced into evidence. And so even when there's a limitation on the item being introduced into evidence, that really goes to the item tested, which here is the environmental sample of trace DNA. And of course, the government has twice tested it. And so for the attorney to be able to fulfill their duty to investigate and satisfy the minimum practice standards, they should have access to the scientific testing of that item of evidence, which is central to the case.
Isn't it just 1 minute? Mr. Mercer, I don't have any other questions. I'm going to hang on just a minute. The prosecutor.
Thank you.
Your Honor, I have no questions for this witness. Mr. and I will be making our legal arguments.
Okay, thank you. Okay, may this witness be excused? Any objection?
No objection.
Okay, you're excused. You can now stay in the court if you'd like.
Thank you very much, Your Honor.
Appreciate you traveling. Thank you. Been about an hour. Maybe I need to give the court reporter a break. How about Mr. Shortland, 5 minutes, 10 minutes, maybe 10 minutes. Yeah.
Remember, that will give me time to have our next witness set up.
Okay, great. Okay, 10 minutes, and we are off the record.